Hello, my name is Brigham Cluff. I am an attorney with the law firm of Cluff and Cluff. I'd like to talk to you a little bit today about analyzing how much your case is worth. I had an experience once with a client, a kid who had a broken leg. This kid was in high school, really great kid, broke his leg very badly. It wasn't his fault, it was the defendant's fault. And we had a very solid liability case, and our damages were also very solid, and nobody's going to question that this kid was really hurt. It's quite evident in the x-ray that he's got a broken bone. So what do you do? How do you get that evidence in? One of the things that I did in that case is I went and visited the client in his home, there with his family. His parents were there. Some of his other siblings were there. And I just spent some time with the family there in the home. And by this time, he was no longer in his cast. We were getting close to trial. And I just got to know the family. And I walked around the house. And I learned information there that I couldn't have gotten in any other way than by going to my client's home and visiting with him and his family. Here's an example. I said, hey, show me around the house if you would. And they said, sure, we'd be glad to. I went into the client's room. I saw that he shared a room with his brother. Right? And they had bunk beds in the room. I said, interesting. What bed do you sleep in? He said, well, I sleep on the bottom bunk. I used to sleep on the top bunk, but after I broke my leg, it was just really tough to get up there, so now I sleep on the bottom bunk. We've never switched. And I thought, okay, that's interesting. This is something that had never come up before in my conversations with the client. It probably never would have had I not been there, right there in the client's home. And so now, instead of having my client get up on the stand and say, yeah, I hurt my leg, it really hurt a lot, and man, I had to switch to the bottom bunk, and I really didn't like that. I preferred being on the top bunk. I was able to introduce evidence in a much more powerful way. We got a photograph of the room and of the bunk beds, and then I had his brother come in and testify. And I said, hey, little brother, what are we looking at here in this picture? Well, that's the bunk beds. This is my room I share with my brother. And then I had him explain the story of how he had to switch bunks with his brother. And that evidence came in, and it didn't sound like whining. It wasn't the plaintiff talking about woe is me. It's somebody else talking about a fact, something that happened. And that was powerful evidence in that case. Later we were going around other parts of the home, and we went into the hall bathroom that was across the hall from the boys' bedroom. Typical bathroom in a relatively small home, combination shower tub in one end of the bathroom, and then next to that there was the toilet, and there really wasn't a lot of room to move around in that bathroom. And I asked my client, how'd you take care of yourself in this bathroom while you were in that cast? He had a cast that went all the way up his leg. It was very cumbersome. And his father was actually there with me at the time, and he said, oh, it was a nightmare. Oh man, he couldn't hardly fit onto this toilet here when he had the cast on because his leg couldn't bend, and he really couldn't take care of himself after he was done using the toilet, and so he needed help, and so I would have to help him do that, and sometimes I wasn't there, and his mom would have to help him do that, and it was awful, and it was embarrassing for my son, and it was embarrassing for me, frankly, and it was embarrassing for my son's mother, and that's something that everybody understands. The jury got it. They don't like having to see somebody suffer in that way, yet my client didn't have to get up onto the stand and sound like he was complaining. I was able to get all of that evidence in another way. So that sort of evidence can be very powerful. It's tangible. The jury gets it, and it doesn't sound like whining. I'll give you an example of a contrast in how to get damages evidence in. Years ago, I was right at the beginning of my career, and I was working at a law firm, and I was the the low man on the totem pole. I was the brand new lawyer, and so I got the cases basically that nobody else wanted at the firm. And I recall getting this one case, and I was going through all of my new cases and looking through the files and looking at the evidence that had been gathered. And in this one file, I was going over it with my secretary. There were photos, and this was back in the days where there were actually paper photos that you could hold in your hand. These days, photos only exist on iPhones, but in those days, you could actually take pictures and you would print them out and hold them in your hand. And I had this picture, or several pictures, of the client, and I couldn't really figure out what was the point of these pictures. And I'm going to try to demonstrate what I saw in the pictures. They were just pictures of the client. They're fairly close up on the client's face, and he was going like this. And another one he was going, oh. And I thought, what's going on in these pictures here? Why do we have these in the file? And my secretary said, oh, this is the client in pain. I said, really? This is our evidence of pain, the client grimacing. And, well, yeah, that's what it is. Okay. That's not going to be persuasive to a jury. It's not going to be persuasive to an insurance company either. The only thing that persuades an insurance company is the fear of what a jury might do with the evidence. And so that's not compelling. It's not persuasive. Anyone can make a grimacing look on their face. Nobody believes that that's really evidence of pain. But there are things that you can do to create very compelling evidence. I mentioned the example with my client, my young client with the broken leg, but you can do that in every case. A lot of times some of your most powerful damages evidence does not come in from the plaintiff in the case. It comes in from people who know the plaintiff. Oftentimes people who don't even know the plaintiff very well. Sometimes it's more compelling that way. It's more believable that way. Perhaps it's a co-worker of the plaintiff. Perhaps it's somebody that goes to church with the plaintiff, or a friend of a friend. Somebody who can come onto the stand and say, yeah, I know the plaintiff, kind of. He's not really a close friend of mine, but I do know him, and I saw him at this event. It was really difficult, and it was hard for him. And you can go through and talk about the real-life damages that have occurred.